Okay, thank you, Janet, for that brief description of the reasons why the Endorois community approached the African Commission, and a brief line on the status so far on the implementation of the decision, which I think also Cyrus will be speaking much more in detail. And I think now this brings us to Andrew Songa, who, as I initially said, was engaged at the beginning of the litigation of this process and later in following up and monitoring implementation. So Andrew will be speaking to us about the lessons learned, the approaches, the tactics that were used in litigating this case, and what can be lifted for other similar cases for indigenous peoples across the continent. Andrew, over to you.
Thank you very much, Japheth, and I'm happy to have the opportunity to be able to reflect on this, one of these seminal cases for the African Commission, as you had highlighted, setting down the yardstick for indigenous people's rights and becoming the platform through which other communities, even in Kenya, such as the Ogiek, were able to then even proceed and take further strides within the African Court and continue to solidify the rights for indigenous peoples, not just in Kenya, but in Africa, as we then saw, as you mentioned, with the work done by the working group on indigenous populations in Africa. So as you've mentioned, I will try and tap into some of the experiences I had with one of the institutions that filed this case alongside the Endorois, and that is the Center for Minority Rights Development, and just try to highlight some of the key lessons that emerged from the process of bringing the communication to the African Commission and what it took to do that and mount that level of litigation and get that unprecedented decision, and therefore reflect somewhat on implementation, but not delve too much into that because I understand Cyrus will speak to it. So to begin with, I would want to put this discussion within the setting or the framing of looking at the Endorois case as one of strategic litigation within the rubric of the concept of strategic litigation. And I will just borrow from the definition of the Open Society Justice Initiative that had done a study around strategic litigation impacts, where they define strategic litigation as legal action in court that is consciously aimed at achieving rights-related changes in law, policy, practice, and or public awareness above and beyond the relief that you actually acquire for the plaintiffs listed in the case. And what does this mean? At its best, strategic litigation will therefore not only yield material benefits for the complainants in the case, it will proceed to trigger progressive legislative and policy reforms alongside the jurisprudence that is generated, and also occasion a change in public attitudes with regards to the issue that is litigated on. At its worst, public strategic litigation then can be a very time-consuming, frustrating exercise, and also maybe even the cause for backlash against the group that is seeking redress. And it can also be very ineffective towards reform. So it's within that shape that I would want us to think through the experiences we will hear today about the Endorois case. With that framing in mind, I will speak through about 10 key points, I think, that we can reflect on with regards to the litigation for the Endorois case. And the first one, I think Janet sort of introduced it for us, and it's that the journey for this litigation doesn't begin in the courtroom, but it begins with the community's articulation and assertion of its rights. And so she mentioned how, for example, the community centered its claims around the fact that they had been displaced from their ancestral lands, and that displacement had caused damage of property, disruption of their way of life in terms of pastoralism, disruption of their religion and culture, as well as the overall development of the community. And that this happened against the backdrop of the community constantly making demands of the state, trying to negotiate with the state, and also experiencing broken promises from the state as they tried to fight for a reclamation of their ancestral lands since 1973. But what do we learn from that arc I would hope, that some of the key features in terms of focusing on communities asserting their claims are three things. The first is that there has to be clarity within the community in terms of what their grievances are, the harm they have suffered, and what their desired remedy is, essentially their ask. The second key element is cohesiveness. It is very important to have a community that is unified in its cause. And that means having very inclusive processes of effective participation, consultation, and informed decision-making about how the community wants to pursue and claim its rights. And then thirdly, it's about resoluteness of the community, that even in the face of threats and intimidation, the community can stand firm, that it can have leaders who will stand steadfast and continue to assert those claims and those rights. I think within the Endorois case, as you think through the experiences, these were three important elements that reflected themselves first within the community leadership itself, and then what was eventually organized and constituted into the Endorois Welfare Council. Secondly, it is also important to appreciate the context that informed the case. That beyond the direct claims made by the Endorois, these claims were situated within wider concerns of indigenous peoples in Kenya. And essentially the core of these concerns were that prior to 2010, we did not have constitutional recognition of indigenous peoples in Kenya. What we did have was some policy statements and referrals by the government that would concede that they were communities that were either collectively branded as minorities, marginalized, or vulnerable communities. Specifically, a 2007 report by the UN Special Rapporteur for Indigenous Peoples after a visit to Kenya kind of encapsulated the concerns for indigenous peoples in the country into about 4 key areas: that they lacked legal recognition and empowerment, which again caused social, political, and economic marginalization, that they continued to suffer the ramifications of the loss of and environmental degradation of their land, primarily as a result of conservationist policies utilized by the state, which in turn violated the economic, social, and cultural rights, and that they also had an absence of social and health services within indigenous communities, which disproportionately affected their women and children and accentuated the discrimination that they endured with regards to the rights to property and as well as harmful traditional practices. But also importantly, the special rapporteur underscored the fact that the lack of transitional justice and redress mechanisms impacted on the human rights of indigenous communities. So we were working in what was essentially a very hostile environment for the furtherance of indigenous people's rights in Kenya. And that takes me to the third point, that once it was clear that there are claims the community has held on to and rights that they wanted to assert, and that we are aware we were in a hostile environment, it was still important to effectively engage with the domestic legal process and exhaust domestic remedies. And what did that then mean? That culminated, as I mentioned, there were attempts at amicable settlements with the government, attempts to have conversations with the state, including with the president, who happened to be the member of parliament for the Endorois, in the sense that the Endorois fell within the president's constituency. But despite different undertakings given by the president, their grievances were not addressed, and I characterized them earlier as broken promises. So this led to embarking on litigation in the Kenyan High Court in 2000, as Janet mentioned. And this proved futile because the court didn't really engage with the substantive aspect of the Endorois claim. They knocked it off on technicalities, remembering that Kenya's Bill of Rights at the time was an individualized Bill of Rights, and that we also had a procedure of appropriating lands for indigenous peoples within what we call the trust land system that had been utilized to take away Endorois land. So rather than engage with the substantive elements that the Endorois had questioned with regards to the aspect of whether or not the trust land procedure had effectively extinguished the ancestral claim of the Endorois to their land, or whether even in fact the procedures were properly followed, the court didn't engage with those substantive issues and dismissed the petition. The community then sought to appeal that decision before the Court of Appeal, but that appeal was actually frustrated by the inefficient judicial system in the country. They had to wait an inordinate amount of time for the record of appeal to be drawn up and filed, and that in its sense frustrated the prospects of appealing the High Court decision. So that takes us to the fourth element. If you then find you have been frustrated by the domestic system, then you turn to the regional African human rights system, and that's how the community turned to the African Commission on Human and People's Rights. And essentially, this was for two core reasons. The African Charter provided an avenue for protection, both in terms of substance and procedure. In terms of substance, I mean the rights enshrined in the African Charter acknowledged essentially what would be indigenous people's rights. The right to culture, the right to religion, economic and social and cultural rights, the right to property as conceived by the Endorois. This contrasted against a prevailing Kenyan constitution that did not provide for all this ambit of rights. And then the second one was procedural, acknowledging the fact that the commission would acknowledge the non-existence of effective, available, and efficient remedies, recalling what I just mentioned about the High Court and the Court of Appeal. And that also the very nature of the procedure of the African Commission was less restrictive in comparison to the Kenyan one. By that, I mean, it had an expanded understanding of who had standing to come before the commission. So as you've seen within the case citation itself, you had two non-governmental organizations, Semi-Right and Minority Rights Group International, coming in on behalf of the Endorois community to litigate against the state of Kenya, against something that would not be possible under the prevailing constitutional context at the time when the Endorois case was filed. So once we were now in the commission, the important lesson that emerged, that now you are arguing your case, is the importance of a merits argument that is backed by strong and innovative evidence. And I think three highlights but would illustrate this. The first is the Endorois case drew in the unprecedented move to allow video testimony within the proceedings of the African Commission. And this was the documentary that had been prepared by the community in conjunction with Semi-Right and Witness that was called The Rightful Place. And just to quote one of the litigants of the case in reflecting on this innovative aspect, they referred to the documentary as having brought the voices of an oppressed community into the hall of justice and strengthened the reality of the indigenous struggle in Africa. So that becomes another thing of ensuring that one of the core elements of arguing your case and putting forward evidence is accentuating the voices of the victims as being at the heart of the argument. The second aspect of innovation with regards to evidence was the utilization of expert testimony to underscore the frailties or the deficiencies and landscape of Kenya's land law. And again, this was done by bringing in one of the leading experts at the time of Kenya's land law, the late Professor Okoth Ogendo, who was very instrumental in unpacking the concerns of the Endorois vis-a-vis the trust land system that was used to appropriate the ancestral lands. The third element was also the utilization of amicus briefs. And in this context, the Center of Housing for Rights and Evictions offered an amicus brief to aid the main arguments of the complainants in the case to illustrate the harms caused by the evictions that had been undertaken by the state. So essentially broadening the constituency of allies in terms of pushing the case forward. As I begin to quickly rush to conclude, the sixth element is being alive to the contemporary developments and sustaining a strong advocacy strategy alongside the case in anticipation of the implementation phase. Now, the Endorois case is very interesting and somewhat unique because of the fortuitous convergence that happened between the delivery of the court's, the delivery of the commission's decision and the fact that Kenya was in a transitional period where we then saw certain elements of reform take hold. So it was very important to be alive to those developments because you're beginning to anticipate emerging frameworks that can work to the benefit of implementing the decision once it comes out. So I'll just give a few quick examples. As the case was going on in about 2006, the Kenyan government embarked on development action plan and policy on human rights. It's first, I believe. And so within that context and using the momentum of the arguments that had already been averred within the Endorois case, you then had a situation where non-governmental organizations such as Semirad were able to galvanize and make a very strong argument for having a thematic focus on minorities and indigenous peoples within that policy and ultimately being included in developing that said policy with regards to indigenous peoples. We had a constitutional review process that went through 2 cycles, a failed referendum in 2005, and then one that finally validated a new constitution in 2010. Within those contexts, this Endorois case had legitimized the claims of pastoralists and hunter-gatherer communities within that constitutional review process. And just to quickly cite some reflection on it, the impact of the Endorois decision on the constitutional review process can be seen as follows. That the Endorois decision became the rallying call in the context of the campaign for a new constitutional for a new constitution in Kenya, that the adoption of this new constitution, which has effectively abolished the trust land regime discussed earlier, created a new tenure arrangement based on communities, constitutes one of the greatest policy gains for these communities in the country. The third example I will use is the Truth, Justice and Reconciliation Commission process that Kenya went through between 2008 and 2013. The Truth, Justice and Reconciliation Commission, the TJRC, in its final report in 2013, dedicated a specific chapter on minority and indigenous peoples. And within that, you will see that the Endorois case decision was pivotal to shaping the Truth Commission's definition and understanding of indigenous peoples. It also contributed to its findings, such as the fact that the state had failed to accord due recognition to minority and indigenous communities in Kenya, that the land tenure system had been hostile to these communities. And in fact, the Endorois case was used to illustrate that failure of the trust land system that I spoke to earlier. And that the infringement of the indigenous people's rights to development as informed by free, prior, and informed consent was also a key finding, and that was located within the Endorois case decision jurisprudence. The commission also went to explicitly highlight as one of its key recommendations that the government needed to implement the decision of the Endorois case. Finally, with regards to advocacy, is also the fact that we were able to effectively utilize the spaces of various UN platforms to advance the cause of the Endorois case that had been litigated in the African Commission. So like within UNESCO, the World Heritage Committee reviewed the status of Lake Bogoria and issued a state of conservation report, which required the Kenyan government to report on the conservation of the lake and urged the Kenyan government to include the Endorois in the management and benefit sharing of the resources accruing therein. And that the case has also featured prominently within the concluding observations of various review platforms, like the Human Rights Committee, like the Universal Periodic Review, and the Committee of Economic, Social, and Cultural Rights, but to name a few. It is also very important, as a lesson to reflect on, that meticulous documentation of your engagements with the state, as well as being proactive and tenacious in updating the African Commission with regards to those engagements, that is an asset to progressing the case. And what does this mean in the Endorois context? The fact that there was continuous correspondences and check-ins, especially after the decision was issued, to require the state to act, enabled us to secure one of the very rare occasions of an implementation hearing before the African Commission under the previous rules of procedure, Rule 112. And it is through that implementation hearing we were able to then procure from the Commission Resolution 257 of 2013, calling on the Republic of Kenya to implement the Endorois decision. Getting to that milestone of the resolution that explicitly called out the Kenyan government, it took a lot of sustained engagement since 2010 when the decision was issued. Looking for every single opportunity to engage with the Ministry of Justice, ask them about a roadmap for implementation, engaging with the National Human Rights Institution, the Kenya National Commission for Human Rights, enlisting them to support the push for calling on the government to trigger a roadmap for implementation, going into the successive ordinary sessions of the African Commission and updating the Commission on the lack of action by the government or clarifying certain steps the government had made. And we did this through oral statements. We did this through written correspondences. All this was very effective in keeping the case within the radar of the Commission and also within the radar of the state itself. And then another lesson is that then, I think as I conclude, is to say that if you take all these different steps into context, and I will reflect on implementation after me, litigating within the African human rights system enabled the Endorois to challenge a state that was intent on limiting the scope of rights and justice. In doing so, they challenged what was the prevailing social contract and obtained jurisprudence that was then of benefit to the wider constituency of indigenous peoples, recalling the objectives of strategic litigation I had mentioned earlier. That they had then gotten protections under the that were not immediately available within our prevailing constitutional framework at the time. That the case inspired transformative aspects with respect to indigenous people's rights, as I've mentioned in our current 2010 constitution and in the final Truth Commission report. And that these processes affirmed and validated the claims of indigenous peoples and maintained or renewed an impetus for redress, that now other communities could now stack onto that and make their own claims. I do recognize that we are going to discuss the fact that implementation in the substantive sense or the material benefits for the Endorois has not really happened. And we have seen also checkered implementation of some of the reforms I've mentioned. Our constitution is there, but we've not really seen the true fruits of some of these provisions with regards to community land, for example, or with regards to addressing some of the aspects of marginalization for indigenous peoples, because the environment still remains hostile politically. But despite these setbacks, the Endorois case does show us that Kenya's indigenous peoples, through the experience of this litigation, do bring with them valid assets for the next phase of the struggle. And that is how I will conclude. There is now an enhanced legal and political empowerment from engaging in the litigation and transitional justice processes I mentioned, which came up in the country. There's an evolved network of solidarity at the national, regional, and international level for these communities. You know, with the case started without a registration of an Endorois Welfare Council, it concluded and swiftly we saw an Endorois Welfare Council, but then we also saw a lot of galvanizing and organizing amongst indigenous peoples to the point where we have forefront civil society organizations representing indigenous people's rights in Kenya and consciously organizing across a variety of issues. And that also there's a civic awakening and potential for generational transfer of the mantle of this cause to a future re-energized generation of activists within the Endorois community and beyond. And that is to say, this case started with a set of community leaders and elders, but even as we've moved through that long journey from 1973 to the 2003 case decision, to the 2010 decision and its implementation, we've seen a succession of leadership, an emergence of new leadership, but a sustained call for the Endorois claim, the Endorois demand for its ancestral land, and hopefully that will continue to reinvigorate itself, revive itself, and sustain what was a journey that started very, very, very long ago. I think I'll close with that, Japheth, and thank you all for your time.
Thank you so much, Andrew, for that really elaborate and comprehensive journey from the lodging of the case to how the case was litigated, to the high points, the new innovative ways of presenting evidence, to following up in terms of the implementation, Resolution 257, the implementation hearing. In a sense, the Endorois decision has had so many firsts and has introduced so many procedural innovations within the African Commission. And this now actually particularly reminds me that one of our participants is Dr. Faye Ogunade, whom, as some of you may know, participated actually in the writing of this decision to go together with Dr. Robert Eno, who is currently the Registrar of the African Court on Human and People's Rights. At the appropriate time, Faye, I'm afraid you will not be able to escape. I'll give you an opportunity to speak about the experience of receiving this case and writing about it, and what are your thoughts 10 years later, given the labor of love that you gave to this particular decision. So Faye, this is a warning that you'll be up for a few minutes.